think we can begin now. I've been told that the sound system of this 11th floor conference room has been improved in the sense that there are two sets of speakers now at front, all directed at everyone here in the center, and the speakers that used to be in the ceiling which used to produce an echo, have been deactivated. So if you have any feedback, hopefully positive feedback about the sound system here, please don't hesitate to report to us what you think. It's a great pleasure this afternoon to welcome Onishi Kosuke to talk about military necessity. I met him when I was a visiting professor at Doshisha in December 2015, January 2016. He subsequently came here to Hong Kong for the International Humanitarian Law Moot, and more recently he started his on the PhD program at Doshisha University in Kyoto. He tried out his paper on military necessity in Israel. He delivered it to some Israeli academics at a conference, and his paper didn't fare very well at the time. It was heavily savaged by his audience. So we're now on a second outing of the paper, and we'll see what this audience in Hong Kong thinks about it. But it's a great pleasure nonetheless, I hope, for him as well, so that I present Kosuke to talk about military necessity.
Thank you, Professor Reyes. Can everybody hear me sufficiently? Okay. Well, thank you for the kind introduction. As introduced, I'm Kosuke Onishi from Japan. And thank you to the audience. If I'm assuming correctly, this is your lunch break, and I hope you find this stimulating and we can exchange views about this topic. Just to give a little context regarding the problem of military necessity, there are practical decisions that militaries must make, and many of these decisions stem on the principle of military necessity. For example, a suspected rebel fighter may come out of the bush in the jungle or out of the desert and go into an urban area, perhaps to do something that is unrelated to the military activities, and thus the question arises as to whether or not the state can use lethal force, such as a drone strike against such a rebel force. Another issue that's coming up is that the potential targeting of persons who don't perform combat functions but who are instrumental in a civil war insofar as they provide the motivation for these conflicts, and they are increasingly coming into the crosshairs of targeting. And then another question arises as to what to do about the potential collateral damage or the incidental loss towards civilian lives. And these questions relate to fundamental principles under IHL, namely the principle of distinction and proportionality. And as I will briefly discuss, these principles are founded upon the principle of military necessity and humanity. International humanitarian law, especially the laws that apply to international armed conflicts, are predicated on a delicate balance between military necessity and humanity. Now, this balance has been struck by the drafters of IHL during the drafting of the very comprehensive conduct of hostilities regime that has emerged after the Second World War and then leading up to 1977 in the Additional Protocol 1 and to some extent Additional Protocol 2. That being said, the conduct of hostility rules that apply to non-international armed conflicts, conflicts that by definition involve a non-state armed group, are famously scant if you look at the black letter law. And this is especially true for lower intensity conflicts that fall under Common Article 3, but it is also true to a great extent even for higher intensity conflicts that reach the threshold of AP2. If you look at the laws in AP2, they're very little to do with the conduct of hostilities. That being said, non-international armed conflicts have proven to be quite violent, and there's definitely a demand for international rules and thus we've seen a transplanting of the rules applicable to international armed conflict to non-international armed conflict through customary law. At the same time, however, what is being transplanted is the balance between military necessity and humanity that was thought to be appropriate for international armed conflicts. Thus, one of the questions is whether or not this balance is appropriate for non-international armed conflicts, which, by definition, involve a non-state armed group. And this question I submit, and as many scholars have already submitted, is that this question is very important, especially because importing IHL rules into non-international armed conflict used to be an exercise where you're bringing norms into a legal vacuum because there were no rules. But now that is not the case, as we know that human rights law is what ordinarily applies between a government and a state, insofar as the conflict is confined to the territory of the warring state. It is my intention today to argue that the principle of military necessity is already causing a number of problems in international armed conflicts. That is because the military necessity that was originally envisaged by the founders of IHL does not accurately reflect many of the necessities that belligerents face today. And as a result, there is a deficit in compliance pull that military necessity is supposed to foster. And at the same time, the way that military necessity is embedded into status and categories actually allows for too much violence, more violence than is necessary against the military apparatus. What that means is that combatants are targetable at all times. At the same time, this is somewhat acceptable in international armed conflicts for reasons that I will get into. But the main thesis here is that these problems are more pronounced and difficult to deal with in non-international armed conflicts, and therefore it may be time to think of a different standard besides military necessity in conflicts involving non-state armed groups, particularly those that have low intensity. So very briefly, I would like to go over what is the content of military necessity and what are its functions. Well, military necessity, the content of military necessity can be found in many military manuals. A rather generic definition can be found in the UK Military Manual of 2014, and this is repeated in other military manuals. Basically, if I can distill it, military necessity allows states to take measures which are necessary for the legitimate purpose of the conflict. That begs a second question: what is the legitimate purpose of a conflict? Well, this has been clear for many years. If we look at the St. Petersburg Declaration of 1868, we can see that military necessity permits conduct that is required to weaken the military force of the enemy. And in addition, we can see that belligerents are allowed to do this as quickly and as cheaply as possible. And we'll get into this a little bit more later, but that is a fundamental difference between military necessity and what is called absolute necessity under human rights law. So what are the functions of military necessity? Well, if you look at the definition in military manuals, you can see that the function appears to be permissive, and that's because it is fundamentally permissive. It allows states to take measures which are necessary. But its original purpose was to be a restrictive principle, and for this reason, a number of scholars, including Meltzer, have stated that military necessity is one of the oldest and most effective restraints that has ever been imposed on warfare. In the first half of the 19th century, there were virtually no legal rules regulating the conduct of hostilities. Essentially, all persons and objects that swore allegiance to the enemy were open to attack and destruction, irrespective of whether or not this contributed to military success. That being said, there were rules relating to chivalry and the professionalism of the soldier. However, as became apparently clear, especially in the Civil War in the United States, this can lead to significant problems. For instance, Carnahan cites the, for lack of a better word, amateurization of the military during the Civil War. Rather than having professional soldiers who were aware of these customs of war, you had basically civilians being plucked out of their livelihood and put on the battlefield, and they were sometimes unaware of what conduct should be. Thus, in the Lieber Code issued by President Lincoln, under Article 14 was kind of a revolutionary idea known as military necessity. And firstly, this states that there are indeed limits in warfare. What is required to win is okay, but all other violence is cruel, and there must be a distinction between what is required and what is not. And finally, all cruel violence is illegitimate and therefore illegal. Now, this is crucial because it posits a realistic restraint. War, by definition, was almost a state of lawlessness, but by allowing states to do what is required to win in war, you can also realistically expect that they will do, what they will not do what is unnecessary. And this has significant compliance pull when the content of military necessity is closely aligned to what is actually required, because an effective military will strive to get rid of waste. You don't want to waste ammunition, energy, time. Therefore, if military necessity aligns with these interests, then almost automatically the limits will be followed. And most importantly, you take these limits, practical limits, and you turn them into legal rules. Now, this is crucial because most military conduct, and this is true today, will not undergo international judicial scrutiny. It may undergo domestic scrutiny. But it's important because the determinations of whether or not conduct is justified by military necessity, and these determinations are to be made by commanders and legal advisors, will do much of the heavy lifting when it comes to limiting violence. Now, today, the role of military necessity has diminished to some extent. Rather than apply the law directly, almost in the same way that necessity in general is applied today in domestic and international jurisdictions, black letter IHL is applied. But military necessity is still important. As I mentioned before, military necessity is embedded into these black letter laws, and they inform its content based on the balance between humanity and military necessity. And more importantly, military necessity ensures or strives to ensure that IHL is not just a set of ideals, but is something that can actually be applied by militaries and something that we can expect will be complied with. Here I'm going to say something quite obvious, but it should be noted that the process of embedding military necessity into IHL is not an exact science. In a way, IHL is predicated on a legal fiction. It's not what is actually necessary that is applied into IHL, it's what the drafters presumed would be necessary. So for instance, the drafters of IHL, and in particular the principle of distinction, presumed that civilians would be innocent unless, of course, they directly participate in hostilities. But the flip side is also that combatants are always posing a threat to the military force, and as such, it is militarily necessary to remove them from the battlefield, which in most cases means using lethal force. Now, once again, this is important, and it renders, it generates compliance pull if what the drafters presumed would be necessary are actually necessary on the battlefield. However, a number of problems occur when these estimations are inaccurate, and these problems will be discussed further in a moment. But before I do so, briefly I need to make the assertion that wars have changed to the extent that tensions are occurring based on what the drafters presumed would be necessary and what is actually necessary. Now, the origins of some of these changes are not new in any way. They're actually quite ancient if you look at some of the details. But the point here is that most of the wars that occur today are taking on characteristics that were not prominent in wars past. So I guess the first assertion that I need to make is the question of what is war? And war, according to a Clausewitzian notion, is that it's the imposition of political will through the use of violence. Now, this has not changed over the years. But what has changed is the way by which this imposition of political will is achieved. Now, traditionally, political will was imposed firstly by defeating the enemy on the battlefield, and then essentially doing what you wish after you've achieved victory. So it was assumed that, firstly, the wars would be fought between the armed forces, and to some extent it was assumed that wars would be fought in a battlefield, some given time and some given space. This translates to the logic of what is called attrition warfare, defined by the Department of the Defense of the United States as a reduction of the effectiveness of a force caused by loss of personnel and material. Now, crucially, IHL is largely predicated on attrition warfare. If we can again refer to the St. Petersburg Declaration, we see, firstly, as I mentioned before, that the legitimate purpose of armed conflict, can only be to weaken the military force of the enemy. We also see that the St. Petersburg Declaration stipulates that for this purpose, it is sufficient to disable the greatest possible number of men. This is where the assumption that combatants must be killed comes from. And that assumption, again, is based on the logic of attrition. But attrition warfare, as noted by a number of scholars, is falling out of fashion because it is inefficient. What is occurring instead increasingly is what are called effect-based operations. Effect-based operations is a doctrine where the belligerents select targets which are most likely to directly influence and bring about their political goals. One characteristic of effect-based operation is that it is most effective when the political goals are achieved while destroying as little of the military force of the enemy as possible. What does this mean? Well, this often means that less violence towards the military is necessary than is actually needed, and a rather clear version of effect-based operation can be seen in the American counterinsurgency doctrine called COIN, where they're preferring to capture instead of kill insurgents because killing tends to dishearten and disenfranchise and cause antagonism within the population that they're trying to win over during counterinsurgencies. At the same time, however, this does have the potential to broaden targets. Maybe, and as noted by a number of scholars, it's not the targeting of military targets that brings about the political will of the enemy, political goals, but it could be a broader range of targets, and I'll elaborate on that a little more. In tandem with the second characterization. The second characteristic of contemporary armed conflict is that the notion of victory has changed as well. As Gabriele Blum notes, the notion of victory, or the goals of armed conflicts in the past, was to restore the status quo. In other words, there would be an aggressor, and the goal would be to fight the aggressor and stop their actions, or conversely, to get rid of a threat to international peace and security. While that's still the case in many armed conflicts today, and that's what the UN Charter is based on, in her interesting paper called The Fog of Victory, she goes on to argue that actually in many conflicts today, it's not to restore the status quo, but to change the status quo. If I may quote from her paper, she refers to Afghanistan after September 11th. So according to Blum, after the attacks on September 11th, the proactive action could not be limited, the U.S. doctrine held, to foiling individual attacks and disabling individual attackers. Rather, the condition that allowed for attacks and attackers to threaten the United States had to be changed, possibly by comprehensive overhaul of the domestic structures of the territorial state. So we see here that generic military victory was perceived as being insufficient. And increasingly, as a result, the political goals become the barometer for success of a military campaign. Another important note here is that this is especially true in asymmetrical conflicts such as insurgencies, where by definition they are political military conflicts. And finally, on a related note, is the increasing asymmetry between parties in armed conflict. So rather than having wars between sovereign states, which are essentially symmetrical in power and also in structure, they all have an air force, an army, and potentially a navy, well, usually a navy. Now it's between states and non-state armed groups, and increasingly for non-state armed groups, military victory is not even seen as a possible goal to be attained. They don't even strive to defeat these state forces. More or less, it's about changing, again, the hearts and minds of the population, and this has significant implications for who is targeted during armed conflict. So what are the implications of these three characteristics of contemporary armed conflict? Well, the first is simply that in asymmetric armed conflicts, atrocities are almost systemic. Firstly, the non-state armed group does not distinguish themselves from the civilian population, but more importantly, rather than attacking the military directly, they choose soft targets. So they directly attack the civilian population in order to give the sense that the government does not have the capacity to govern and essentially win over the hearts and minds of the civilian population through brutality. So we see this in the Syrian war, Syrian civil war especially. As Milantowicz notes, one of the primary strategies, not only of the rebel forces, but also of the government, especially after the rebels have won over the hearts and minds of the population, is population expulsion. And this is done through atrocious behavior, directly attacking the civilian population, sexual violence, and of course, we see the bombings on the news almost every day. So here there's not much that military necessity can do. It's more of a matter of impunity, but I would say that this is especially problematic in non-international armed conflict. In non-international armed conflict, the restrictive function that military necessity is supposed to play does not really work, especially in relation to the non-state armed group. This is because the permissive function does not function in relation to the non-state armed group. What I mean is, even if the non-state armed group follows IHL, they do not enjoy combatant status. Of course, they may be granted amnesty, but more or less, they will be tried under domestic criminal law. And in the case of Syria, that means that you will most likely be subject to the death penalty. If you're going to be subject to the death penalty, irrespective of whether or not you follow IHL, there's very little incentive to do so. For this reason, a number of scholars have recommended recognizing the belligerency of such non-state armed groups, which would solve this problem to a large degree, but the probability of that happening is somewhat unrealistic because states will generally not want to grant recognition to such non-state armed groups. Now, there's a similar issue, but the difference here is that it does not result in blatantly illegal conduct, and that is that belligerents will be tempted to expand targets, and IHL simply is not clear enough to contain these expansions. So the first has to do with human targets in non-international armed conflict. Fighters in non-international armed conflict, what are called unlawful combatants by the United States. And as I mentioned during the introduction, increasingly political and cultural and religious figures are thought to be quite dangerous and qualify as targets in the eyes of belligerents. For example, al-Baghdadi of Islamic State, or the quite famous targeted killing of Anwar Anwalaki are good examples here. Now, notwithstanding this increasing, let's say, demand by the belligerents to expand what they define as human targets, there's not enough clarity currently in the law applicable to non-international armed conflict to distinguish between whether or not the target is a legitimate target or not. The direct participation in hostilities standard is still, in my opinion, and the opinion of many scholars, imperfect, and there's been massive controversy over the years, notwithstanding the interpretive guidance by the RCRC. Even more so is the notion that there is some sort of fighter or a quasi-combatant status in non-international armed conflict. So, of course, the ICRC introduced what they call the continuous combat function status. So if you're continuously directly participating in hostilities, you are a de facto combatant for the purpose of targeting, and you can be targeted irrespective of your conduct. Again, this standard has been criticized as being too narrow by some and too broad by others. And then there are a number of other standards adopted by states, such as the United States and Israel, etc. So the law is murky there. And even if the law is clarified, which is a must, this will somewhat always be murky. As a matter of fact, it's very difficult to distinguish between fighters and the civilian population. Unlike in international armed conflicts, they do not wear uniforms for the most part, and as I mentioned before, they have very little incentive to do so if they're not granted POW status. This is particularly troubling in light of the fact that the International Court of Justice has decided that the lex specialis principle will dictate that IHL may supersede human rights standards. Now, of course, we can argue what is meant by the dicta in the court in the nuclear weapons advisory opinion and later in the Palestinian wall advisory opinion, but one compelling approach, and the approach taken by states, is that if you are a target under IHL, then using lethal force against that target will be legal even if human rights standards apply. Now, given that human rights is supposed to prohibit arbitrary killing with relation to the right to life, this is quite troubling given the malleable definition of fighters and the lack of clarity regarding who can be targeted. Another related issue has to do with the objects that can be targeted. Once again, the definition of a military objective under IHL can be found in Article 52 of AP1, and there are two prongs here: whether or not the object contributes to militarily, and whether or not the attack will give the attacking party some sort of military advantage. But once again, belligerents are increasingly inclined to adopt broader definitions of both military contribution and military advantage, especially if we look at the changing notion of victory. So if the notion of victory is to change the status quo, such as was the case in Iraq, then increasingly targets that have to do with the communication lines between the regime and the civilian population, for example, will become appealing targets. And indeed, the second, I think it was 9%, but the second largest category of targets during the Iraq War was reported to be such targets having to do with the communication between the regime and its people. On a related note, there's also the principle of proportionality in IHL, and this balances military advantage, which is connected again to military necessity, and incidental loss. Again, belligerents will be tempted to expand their definition of military advantage, which will, in their eyes, justify more incidental loss. Aleppo is quite a good example here. It's been reported that maybe the large collateral damage is really not only to target the rebel fighters, but also to affect the morale of the civilian population. notwithstanding the fact that the states involved are consistently stating that they are targeting the military. The reality could be both, but the fact is that the military advantage standard can be so malleable and difficult to calculate that it's hard to distinguish between the two. And this is in particular in the case with non-international armed conflicts. As argued by Robin Geis, in asymmetric constellations that elude both temporal and spatial boundaries, in other words, the traditional concept of the battlefield, it would seem somewhat difficult to delineate and determine with any degree of precision what is meant by the notion of an attack as a whole. And of course, here, attack as a whole is the unit against which military necessity must be assessed. So what he is saying is if there is a lack of an identifiable battlefield or a time, temporal scope within which the conflict is taking place, it becomes much harder to distinguish between political necessities and purely military necessities. Thus, according to him, the principle of military necessity and military advantage has the danger of falling into oblivion, in his words, in non-international armed conflict. A third implication goes in the opposite direction, and that is that, as alluded to in the introduction, that IHL actually allows for too much violence against the military. As I mentioned before, effect-based destruction, effect-based operations makes the destruction of the military excessive. For instance, their political goals may be in reach if you simply attack the air force of the opposing military. Of course, this depends on the conflict. And additionally, new technology might also play a factor here. If you can disable the military through cyber attacks, then completely destroying the military physically would also become excessive in theory. Asymmetry also has a role to play here, and that is that if one party has significant control over a specific area, then killing may actually be unnecessary. As alluded to by Sassoli and Olson, there's a sliding scale between situations that essentially resemble peacetime and situations that resemble full-scale war. Now, again, why this problem exists is because IHL is based on attrition warfare. And we see this problem being addressed by a number of NGOs and scholars, and especially and infamously the Red Cross. In Part 9 of the Interpreted Guidance on Direct Participation in Hostilities, famously the ICRC stated that it would be against the principle of humanity to kill a fighter, even a combatant, or perhaps a civilian directly participating in hostilities. To be clear, in the guidance they used the example of a civilian directly participating in hostilities, but that it would be against the principle of humanity to kill such persons if capture or injury is feasible. Of course, this has been heavily criticized by a number of scholars, but it has also gotten the support of a number of scholars. Again, Gabriele Blum takes a more macro approach and say maybe even entire classes of soldiers might not fall under the ambit of military necessity because their functions have very little to do with combat. And perhaps it is possible to go even further. If you take Hill Cawthorne's approach to military necessity and armed conflict, where he states that armed conflict is a state of emergency that can be confined to time and space, you might be able to argue that while IHL, as a matter of law, applies to the entire territory of a state, there might be certain areas that are the hotbed of hostilities, but then other areas, again, as Sassoli notes, that are more akin to peacetime. And in doing so, you can assess whether or not military necessity exists, and where military necessity does not exist, peacetime standards such as human rights should prevail. So one example is Russia. So IHL, if there is a conflict between the Russian government and Chechen separatists, IHL as a matter of law, would apply to the entire territory of Russia, but perhaps you could say that military necessity only really exists in Chechnya. It would be sort of a stretch to say that military necessity exists perhaps on the east coast of Russia in such a circumstance. Similarly, at the preliminary stages of the conflict in Syria, the ICRC stated and then immediately retracted, but originally stated that there is an armed conflict in certain areas such as Homs. So once again, we see here there's a territorial limit perhaps to where military necessity exists. And then there's also the rather repeated example of the FARC fighter in Colombia who occasionally goes into Bogota to go shopping or to visit the family. It may be possible to argue that military necessity does not exist in Bogota insofar as they are not armed and surrounded by their comrades, and as such, peacetime standards should prevail. But again, there are many critiques of this ad hoc recalibration of the balance between military necessity and humanity, one of them being, don't upset the balance that the drafters have created in IHL, because this balance creates clarity. That's true to a great extent. If you say, okay, combatants can be killed, but the trade-off is you cannot attack civilians, that is clear as a matter of law. I will say, however, that this argument is less convincing in non-international armed conflict, not least because the balance has yet to be struck, especially with relation to the definition of fighters, as I alluded to before. You don't get the benefit of clarity in that circumstance, or in relation to non-international armed conflict. Another problem is that in international armed conflict, you can somewhat accept that the military is always open to attack because you have the added restraint of the jus ad bellum. Increasingly, scholars have argued, and it's becoming rather mainstream, that the proportionality and necessity requirements of the jus ad bellum continue to apply throughout the conflict. So eventually, if it is disproportionate to attack the entire military, then the jus ad bellum would dictate that no more attacks can be justified. And so while you can say, okay, IHL justifies the whole-scale attack of the military, there's jus ad bellum creating a external cap on the attacks there. Of course, the jus ad bellum does not apply in non-international armed conflict, so here I submit that we do need some sort of external cap to protect the military from excessive violence. So if I can recap, the problems stemming from the principle of military necessity, namely the broadening of targets and the inability of IHL to contain these broadening impulses by the belligerents, and too much violence being justified against the military. And here, one of the potential solutions is to inquire on a case-by-case basis what the legitimate aim of the armed conflict is, and then determine what is necessary for that legitimate aim, rather than assuming that attacking the military is always legitimate. So this is crucial in non-international conflict, again, because status is malleable, and once again, because non-state armed groups do not benefit from POW status, and as such, they have very little incentive to follow the law. So given these challenges, the question that I mainly want to pose today is whether or not military necessity and its balance against the principle of humanity should be imported to non-international armed conflict in relation to the conduct of hostilities. And as such, perhaps it is a good idea in certain areas to preserve the distinction between international armed conflict and non-international armed conflict. So I have just a little bit more time, and using that time, I'd like to present a potential alternative. I must admit, this is still a work in progress, but one potential alternative is to rely on human rights law for determining the legitimate aim of low-intensity armed conflicts. So very briefly, what are the legitimate aims of depriving life in human rights law? Well, if you look at the treaties, it becomes quite clear. In the ECHR system, it's listed under Article 2.2c, especially that states may take measures to quell insurgencies. Granted, the target must be posing a threat to life and injury, which is a significant difference from military necessity. Under the ICCPR jurisdiction, it's similar, once again, that states may deprive lives to protect the life and limb of others. Here I'm arguing that this could be the base for the legitimate aim of low-intensity armed conflicts. What are other crucial differences between military necessity and absolute necessity under human rights law? That is that under absolute necessity, the use of lethal force must be a last resort, whereas under military necessity, it is often justified as a first resort. What it means to be a last resort under human rights law is that all less harmful means must be exhausted before resorting to lethal force. And one final important distinction here is that under human rights law, there are a number of positive obligations that a state must take. Now, we could go through all of them, but most importantly and interestingly is that states must take a positive obligation to minimize the circumstances where lethal force would be necessary. So we see case law in the ECHR where states are required to train and equip their police or armed forces with non-lethal techniques and weapons, and failing to do so would result in a violation of the right to life because it made the necessity to use lethal force more or less inevitable. So one potential framework in low-intensity armed conflict would be to determine on a case-by-case basis whether or not these more stringent human rights standards are appropriate, and ask the state to explain why they are not appropriate. Now, this is significant and, in my opinion, superior to simply relying on IHL's lex specialis, because it captures the meaning of necessity in that it is a factual state where the boundaries of peacetime law are inappropriate, and it also captures the notion argued by Hill Cawthorne that armed conflict is a state of emergency, and such a state can be confined in time and space. It emphasizes facts over legal formalities such as combatant status and fighter status. Now, it would be quite a stretch to say that human rights standards should inform IHL, but I think it is feasible to allow human rights standards to continue to apply and not have IHL derogate automatically as lex specialis. This framework would require the state to build up with human rights standards being the basis. And in explaining why these standards are insufficient or inappropriate, we could begin to see an emergence of what the legitimate aim of the specific operation or conflict would be. So, for instance, if a state were to argue, as was the case in Isaiva et al., that there are armed groups and that they have very little control over the territory of Chechnya, then it becomes clear that one of the legitimate aims of the conflict would be to regain control of the territory, and that conduct that is necessary for this and advantages that, advantage can be aimed vis-a-vis this legitimate purpose. Another could be that the presence of armed groups in the area simply made it so they could not use the absolute necessity standard. In other words, it was too dangerous for their forces to use lethal force as a last resort. And here again, we could see the emergence of what the legitimate aim could be, which is to suppress the armed group and bring the levels of violence closer to peacetime norms. Now, admittedly, this still is rather an open standard, and we should give the state a rather wide margin of appreciation. But hopefully through this practice, what will emerge is something superior to what is the status quo, which is where states essentially argue that the attack was proportionate and that the incidental loss was justified by military advantage without necessarily being able to explain what that military advantage was. Alternatively, it also will hopefully mitigate part of the problems where states somewhat arbitrarily designate victims of targeted killings as combatants. So for example, one of the criticisms of the American policy right now is that in arguing and in showing that their collateral damages numbers are quite low, there has been criticism that, in fact, what they're doing is stating that the victims of collateral damage were actually fighters without giving adequate explanation as to why they thought that they qualified as such. So rather than accepting these rather arbitrary arguments at face value, by bouncing the legitimate aim of the conflict off of human rights law, hopefully we can begin to see clear standards for what military necessity is and what military advantage is. Now, there are a number of shortcomings to this approach, and I'm very low on time, so I'll just briefly state that the biggest obstacle is that naturally this only really affects the state, because currently non-state armed groups are not, of course there are arguments that say they are bound by human rights law, but most would agree that they are not. And this is something that needs to be overcome. But to summarize and to conclude, military necessity was predicated on symmetric conflicts between sovereign states, and it is coming under significant pressure and it is causing problems when it is applied to asymmetric conflicts, and we must pay attention to these problems and hopefully come up with a solution. Thank you very much for your attention.
Thank you very much. We have time for questions. Would anyone like to raise questions? Yes, Melissa.
Thank you for the excellent presentation.
If you just press the button so we can all hear you.
I did. Is that okay? Thank you for the excellent presentation. The way I followed your presentation is that military necessity for you seems to be a mechanism to protect the state army, the formal armies of the combatants against unnecessary violence. Don't you think that, given the narrative, the history of military necessity as a principle, that it is a principle which should be available to the civilians as a mechanism to hold the armed groups accountable for atrocities, rather than a mechanism to protect the military forces against the unnecessary violence of each other? The second question is that, don't you think that this approach, which is based on the principle being a mechanism for civilians to hold militaries accountable for atrocities, don't you think that if we use this kind of approach to the principle, you would therefore come to the conclusion that the principle would also apply to non-state armed groups, and that therefore there is no distinction between international conflicts and non-international conflicts, because the very purpose of the principle is to provide the civilians a mechanism to hold any force using military equipment or any form of violence accountable for their actions under international law. Thank you.
Okay, yes, I'll do that. If I may start with your second.
I think we'll do the other way. We'll get some questions first, and then I'll give them to you. Professor Garlitsky.
Yes, this was very interesting. Thank you very much. Some remarks, one of your last conclusions was that military necessity fits better to a regular international conflict than to these new types of conflicts. I must say I'm not sure, because this all depends on what we understand by military necessity. And I can easily imagine, and this was, I suppose, also the previous question, I can easily imagine that if we are sufficiently demanding in delimiting the boundaries of what is and what is not necessary under this military necessity concepts, it could have quite a protective meaning in both situations. The problem is that we do not know who exactly has a power or jurisdiction to set these boundaries. And this is also my question, because, well, they are some doctrinal works you referred to. There are some international law documents or quasi-international law documents like Red Cross documents, etc. But do we have enough case law concerning the problem of military necessity? I'm afraid not necessarily. We may have something on the domestic level. For example, the Israeli Supreme Court has a very interesting case law. But generally speaking, there is no body which has or is ready to assume a final word in defining this is not military necessity, you acted against the law, you acted within the law. And this makes probably one of the most visible differences between international humanitarian law and international human rights law, because then under human rights law, usually there is a jurisdiction, a court, or the UN Committee for Human Rights, which has a possibility to examine individual cases and to decide whether there has been a violation or not. And this, of course, makes the international human rights law more attractive. Not necessarily must the international human rights law's conclusion be different from the conclusion resulting from the IHL. I can easily imagine, okay, you mentioned that under the European Convention, I think also under the UN Covenant, the use of lethal force must be absolutely necessary. Now, what does it mean, absolutely necessary? I can easily imagine some kind of incorporation of military necessity doctrine, and the first question then would be, was it necessary under the military necessity doctrine? If not, it's easy. There is automatically a violation. If yes, then perhaps we also should add some more demanding requirements, or perhaps not. But on the other hand, international human rights law also may contain some traps. For example, under the IHL, the only beneficiaries are, let's say, hostile victims. Combatants, civilians, doesn't matter. Under the human rights law, also the soldiers on our side are under protection. And now the question is, if there is a conflict, if some maybe not so absolutely necessary killing on the other side could be justified by avoiding the danger for soldiers who are also under the protection of the European Convention or other human rights instruments ratified by the state. Can we balance it? And how to approach this problem? There has been no answer as yet, at least in the case law of the European Court. But this problem has already been submitted. On some occasions, somehow it was avoided to decide, but sooner or later it may emerge. And this is one. So this may be a disadvantage to go to the international human rights law. An advantage on the other side might be, and I think you also mentioned this, that well, military necessity is rather doctrine focusing on the substance, on the situation. So in this particular situation, was it necessary or are there sufficient military arguments to demonstrate necessity or not? Human rights law is also procedurally oriented. So then there are always next questions. Even if it has been necessary, but has this operation been planned in a manner which made it unavoidable to create a situation in which lethal force or the use of lethal force may indeed be military, necessary from the military point of view? Has there been some kind of investigation afterwards? And several decisions or judgments of the European Court of Human Rights is more or less concentrating on such approach. We do not enter into any assessment of the substance. This is not our competence to do it. Maybe it was necessary, maybe not, we do not know. But in any case, what we know is that, for example, procedural obligations like the subsequent investigation have not been fulfilled. And so we have a violation of the convention, and everyone should be happy. So this is also an advantage which may be given by international human rights law, but generally speaking, international human rights law is very ill-suited to intervene in armed conflicts. I think that the very concept of the human rights law is that there is a peace and rule of law. If there is no peace and if there is armed conflict of any kind, then sometimes these interpretations have to be stretched almost to the logical limits, but maybe it's better than to resort to IHL, which might be more logically acceptable when we are talking about the military conflict or armed conflict, but where there is no jurisdiction to decide finally who was right and who was wrong.
Thank you. Perhaps one more question? Does anyone have another question that anyone would like to ask? If not, let me summarize or attempt to summarize what I believe to be the 5 questions asked, and I may not summarize them accurately, but I'll try. I think Melissa's question comes in 2 parts. The doctrine of military necessity is there to protect the non-military persons, innocent civilians, for instance. Is that not the basis of military necessity? If you agree with that, if that is the basis of military necessity, then the whole point of military necessity is to hold people accountable for going beyond what is necessary in a military sense. And if that is the case, then really, why should there be a distinction between the criterion of military necessity in international conflicts and non-international conflicts? The whole point of the doctrine is to hold people accountable for exceeding what is necessary, to hold people accountable to civilians. Professor Garlitsky's questions I find a little harder to summarize, but let me attempt it. The first one is this. Is the language that you've used, or is your thesis really of any practical value? Because it all depends what we mean by military necessity. And military necessity can change with particular circumstances. Military necessity itself depends on the facts of a particular situation. And that is effectively the solution that you were suggesting at the end. In the end, you were saying it all depends on the facts. On the facts, you can use human rights law. You can, to use Professor Garlitsky's words, stretch human rights law depending upon the facts. So rather than stretch IHL, you suggest stretching human rights law. But I think Professor Galitsky is saying, well, are we just doing semantics here? What we're talking about is what is necessary, and what is necessary, military or not, depends on the particular conditions. The second observation or question put on is, let's assume that there is a range between international humanitarian law and human rights law. One absolute necessity, the other military necessity. You suggest a balancing between the two of them in a given situation. Is it possible to balance? How does one balance, especially given a lack of case law? There's a lot of case law in human rights law because that's more domestic. But on the international front, there's very little on international humanitarian law and what exactly is necessary in those circumstances. The third question is this. The third question or third observation put by Professor Galitsky is this. Are you not leaving out the procedural angle? Human rights law, well, Sir Henry Maine says that effectively the substance of the law is to be found in the interstices of procedural law. Human rights law, to a large extent, also looks into procedure, adjectival law, whether proper procedures have been followed. If proper procedures have not been followed, then it may be that one is put into a situation where something is necessary, but had proper procedures been followed, there would be no such necessity. Human rights law investigates the procedural. Why can't human rights law be used in any event? In war situations, in international humanitarian law situations, because regardless of military necessity or non-military necessity, one can always look at the procedural. Were proper steps taken in order to avoid whatever is said to be necessary, whether military or not? I think that summarizes the 5 points put to you. How would you like to respond?
Thank you for those questions. Based on the questions, I think we are all basically on the same page. Melissa, if you don't mind, I'm going to answer your second question. Oh, no, excuse me. I'll answer both of your questions in order. And you're absolutely right in that military necessity is originally meant to protect the civilian population at the cost of the military apparatus of the state, including combatants. My concern here is that this is subject to change because the military is the factual distinction between who contributes to the military effort and who does not is less clear. You see significant outsourcing towards civilian contractors in the U.S. military especially, and they continue to do military functions, and then at the same time you have soldiers who are technically combatants under the Geneva Convention who do not fight, and although they go through basic training, their function in the military is essentially no different from a civilian. So what I'm saying is that although there is, as you say, the purpose to divide the military and the civilian and then protect the civilian population, this is not what's happening in reality, and as a result, belligerents are increasingly tempted to expand towards the civilian realm, violence towards the civilian realm, but then at the same time, maybe not so much violence will be required towards the military. And then you ask that if that's the case, why not apply the same standards to non-international armed conflict? And so let's assume that, yes, military necessity is exclusively aimed at the military and then not aimed at the civilian population, which is doctrine, as a matter of fact. The problem here that I'm trying to highlight is that in non-international armed conflict, the military is difficult to define as a matter of law and difficult to identify as a matter of fact. So this clear distinction between military and civilian is failing to a large extent. And then to essentially, rely on military necessity to justify what would be, during peacetime, unheard of levels of violence is quite dangerous. And at the same time, it's not it's not producing the results we would expect when applied to non-state armed groups. Because as I mentioned in my talk, the restrictive function that's supposed to protect the civilian population does not function so well unless you also have the permissive function. So non-state armed groups will not be compelled to only attack the military of the state if it makes no difference in the end, and they may be sentenced to the death penalty regardless of whether or not they attack the military and the civilian population. I hope I answered your question. Please let me know if there's more that I missed. Professor Garlitsky, thank you for your comments. I'm afraid I don't have an answer to this. I'll definitely think about it, and ultimately I think it'll impact my paper very much. I will begin by saying that you're absolutely right in that there's not enough case law and no central authority to determine the content of military necessity. In fact, what has occurred, and especially if you look at the case law in Nuremberg, is that the question of what is militarily necessary in a given fact is to be determined by a reasonable commander. It's not fair for a court after the fact, sitting in a peaceful situation such as this, to go and tell a commander, well, you made a militarily wrong calculation, even though you're being fired at from all directions and things like this. So that is a considerable weakness to military necessity, and it's also one of my concerns, is that there are no real ways currently to delineate what is militarily necessary and not. But once again, that is why we may be able to rely on human rights law, which brings me to your second question, is how to balance between military necessity and human rights law. And here, again, I don't have a concrete answer, but my hope is that even if you give the commander significant margin of appreciation as to what military necessity is, and this also relates to your third question, is that the procedural requirements under human rights law will begin to start inquiring in a way that will bring to light some sort of understanding on a case-by-case basis what separated the situation at the time from peace. So, for example, we see the Isaiva et al. Case, and the federal forces did not have sufficient control over the area, and that could be the point that distinguished that particular situation from peace. And then from there, we use that as a starting point to see, okay, what is the legitimate aim of your attack? And then we measure advantage against that aim, and then we start to get a clear sense of what military advantage is. As insufficient and as unclear as that may be, my submission is that it's still superior to what is the status quo, which is when we don't really know what the military advantage is on a case-to-case basis. So, yes, I'm afraid I don't have a sufficient answer for you in that regard either. Your final question with respect to the difference between human rights law and IHL, and that human rights law looks to the procedure, it is my intention precisely to rely on these procedural issues to determine whether or not attacks under IHL are required. So one case in particular, I'm afraid the name of the case slips my mind, but this is another Chechen case where in the Caucasus, the federal government said that if you are not an armed group, please hold up a white cloth, and the authorities will come check and see whether or not you're a non-state armed group. And then they found, I believe it was 5 men, and the pilots said that they had light weaponry and they failed to comply with the procedures, and they opened fire thinking that they were a non-state armed group. Ultimately, the court found that this was a violation of the right to life because they did not adequately check with headquarters sufficiently to see whether or not these were indeed members of the non-state armed group. This is something that IHL needs. These procedural safeguards will prevent the arbitrary delineation of who is a fighter and who is not, and will hopefully scale back what what in many cases are arbitrary and post facto kind of excuses to why certain people were killed during non-international conflict. Thank you very much for your comments.
I think that concludes today's session. As I said, Kosuke is just finishing his first year as a PhD student, so that there are another 2 years to go. We look forward to the final product, the final PhD, the actual dissertation, but we're grateful to him for sharing his thoughts, initial thoughts, work in progress thoughts this afternoon. Thank you very much.